In a landmark judgment recently, Honorable Supreme Court of India has declared R.N. Ravi's decision, Tamil Nadu Governor's decision, to withhold assent to 10 Legislative Assembly bills of Tamil Nadu as illegal. So this move of Tamil Nadu's governor of withholding assent to 10 Legislative Assembly bills of Tamil Nadu state has been declared as illegal and against the constitutional provisions of our country by the recent judgment of Honorable Supreme Court of India. Now, this ruling has reasserted the limited discretionary powers of governor as an institution in our country, and it reinforces the primacy of elected state governments vis-a-vis concerning the implementation of laws and enactment of laws in our country. So the bench comprising of Justice J.B. Partiwala and R. Mahadevan has declared this governor's action as illegal and unwarranted. Now, this would significantly help the opposition ruled states, where governor, who's the representative of the central government, sometimes stalls legislative bills by taking no action against them. Now, many times you must have heard, wrong action leads to wrong outcomes. But sometimes inaction leads to even wrong outcomes of even broader sense. In this case, we will be talking about inaction of governors. Now, as you know, governor is the head of the state in our country. The head of the country, constitutional head of the country, is President of India. The constitutional head of a state is Honorable Governor. And Article 163 of our Indian Constitution outlines the general powers of governor in our country, highlighting that governors would be acting on the aid and advice of the Council of Ministers, except in certain discretionary matters. Now, what is this issue all about? What is the judgment talking about? And what are the time limits given by the judgment in relation to how a governor should act in sort of these discretionary powers and how a president should be acting in these discretionary powers? All things we'll be trying to understand in today's session. Hello, my name is Preetpal Singh and you're watching Perspective. Now, as I've already told you, Article 163 talks about governor in our constitution. Now, there is one more article, Article 200. Now, this article specifically talks about the options available to the governor when the bill is presented to the governor after passing in the state legislative assembly. Now, all of you know that in our country, how a bill becomes a law. First, it's passed in the Lok Sabha, lower house of the parliament. Then it's passed in Rajya Sabha, upper house. Then it goes to the president for president's signature. President assents the bill and eventually it becomes a law. It turns into a law. In states, it works in a different way. In states, state legislative assembly, they pass the bill. That bill eventually goes to the governor. Now, governor have certain discretions while allowing to give assent to the bill or withhold the assent to the bill. So, governor in this relation has 4 choices. The 4 choices are very simple. One choice is to grant assent to the bill and pass the bill and make it a law. Second is to withhold assent to the bill. And third is to reserve the bill for consideration of the president. And fourth is to return the bill to again the Legislative Assembly for reconsideration, except it shouldn't be the money bill. So all these options are available for the governor under Article 200 of our Constitution. But there is one very big problem in this particular article. Now, the governor may return a non-money bill as soon as possible with a message for reconsideration to the State Legislative Assembly. And if the bill is passed again by the State Legislative Assembly, then the governor is bound to give an assent. Which means that the governor is having a limited discretionary power over here. If the bill is again passed after reconsideration of the State Legislative Assembly, if the bill is again passed, then the governor has no choice but to give assent. However, the problem is that there is no specific time frame given for the governor to act, which is why the governor chooses inaction. If a governor chooses that I'm not acting on this bill, basically a pocket veto, it is going to paralyze the functioning of the state assembly. And it is going to paralyze the function of the state government as well and would lead to policy paralysis. And this is what has happened in Tamil Nadu. And this is not the first time it has happened in any of the states. It has been happening in our country since last many decades, where governors have been withholding assent or sometimes not taking any action on the bills passed by the State Legislative Assembly. And if no action is taken, like not even withholding the assent, not even giving the assent, not even reserving it for president, doing nothing, just not taking any action, that also leads to serious consequences if we talk about how bigger impact it will have on the functioning of the state government. And this indefinite delay, it has led to several legislative deadlocks, and multiple times center-state relations have become sour because of this particular reason. But if you look at Article 200 closely, it uses the word shall, which means that the governor is bound to act on this particular bill which means that the constitution makers, they wanted the governor should not be withholding the laws, the bills indefinitely without any assent, but they should act within a reasonable stretch of time. But what was that stretch of time? In our constitution, it wasn't mentioned, and which is why in this case, Honorable Supreme Court of India had to intervene. Now, this is not the first judgment in this regard. There have been two earlier judgments as well, which we'll be seeing, and from those judgments, evolutionary, this 2025 judgment becomes a very supreme judgment and a very landmark judgment as well. Now, first judgment for us to see is, so in 2016, the landmark judgment of Nabam Rebia and Bamang Felix versus Deputy Speaker. This judgment highlighted that the Supreme Court has emphasized that the governor cannot withhold the assent to these bills indefinitely. So governors can't withhold the assent to state legislative assembly passed bills indefinitely. That is one thing. And also, second is that if the governor has any concerns, they should be writing a message alongside the reconsideration, and a message needs to be sent to the state legislative assembly for a reconsideration of that particular legislative assembly bill. That is 2016 Nabam Rebia case. Now in 2023, another landmark judgment was there in this regard. That was State of Punjab versus Principal Secretary to the Governor. Now this case involved a dispute between Punjab government and then Punjab Governor Banwari Lal Purohit, where the governor refused to give assent to certain state legislative assembly bills, citing irregularities and also claiming that the legislative assembly session was illegal. Now in this regard also, Honorable Supreme Court of India intervened and gave certain judgment. Now while ruling in favor of the Punjab government, Honorable Supreme Court of India said that governor is the unelected constitutional head of the state and governor must not obstruct the legislative process in the country, which is why this judgment becomes very popular and it becomes very important, that the Honorable Supreme Court of India says that governor is the unelected constitutional head of the state, should not interfere in the legislative assembly or should not obstruct the legislative process of that particular state. And it also says that if the governor chooses to withhold assent to the bill under Article 200, they must follow the first proviso under that. That is, return the bill for reconsideration of the state legislative assembly and not stall the bill and do not take any action indefinitely. So inaction should not be taken indefinitely. And the bill should be sent to reconsideration of the state legislative assembly. That was in this 2023 judgment. But this judgment is quite different, because in earlier judgments, the court stressed upon that governors should not be obstructing the legislative assembly works and the bills and the formation of law in the states. But in this particular judgment, Honorable Supreme Court of India has intervened and given a specific time period in which the governor of the state and president of the country needs to act. So specific time frame, time guideline has been provided by the Supreme Court now. Now let's divide these time frames into different parts. So the first part is that if the governor decides to withhold assent to the bill or send the bill for reconsideration to the president, that action must be taken within a period of a maximum 1 month. And that too on the advice of the State Council of Ministers. That is first part, first time provision. Now the second is that if the governor withholds assent to the bill, contrary to the opinion of Council of Ministers, in that case, governor with a message needs to send that bill for reconsideration of the State Legislative Assembly within 3 months. So first provision for sending to the president or withholding the assent, first provision gives a time frame of 1 month. Second provision, this provision, where the governor is not acting in cognizance with the State Council of Ministers and withholding the assent to the bill, in that case, the governor needs to send the bill for reconsideration to the State Legislative Assembly within a period of 3 months. So this is the second time frame. Now third provision is that if the governor chooses to reserve the bill for the president, contrary to the opinion given by the Council of Ministers, in that case as well, that action must be taken by the governor within the 3 months maximum time period limit. So the bill to the president should also be given for the consideration of the president, contrary to the Council of Ministers. That also should be done within 3 months. So first is, if the Council of Ministers says so, in that case, 1 month time period is there. In second condition, if the Council of Ministers are not agreeing, still governor can send a reconsideration bill for reconsideration within 3 months. The second is that if the governor is not following the advice of the Council of Ministers and still decides to withhold the assent and sends the bill for reconsideration, that also needs to be done within 3 months maximum. And the third provision is also that contrary to the opinion of the Council of Ministers, if the governor believes that the bill needs to be given to the president for reconsideration, so in the third provision as well, if the governor, contrary to the opinion of the Council of Ministers of the state, decides that the bill needs to be reserved for the president, that action should also be taken within maximum of 3 months. These are the very three important time limits enshrined by the Supreme Court of India. And now comes the most important part. If the bill is sent to the State Legislative Assembly for reconsideration, and the State Legislative Assembly reconsiders it, then according to the Constitution, Governor should give assent to it, but there is no time frame. Now, Honorable Supreme Court of India has put a time frame to it, that within 1 month, a reconsidered bill needs to be given assent to by the governor of that particular state. They don't have any choice. And Supreme Court also says further that failure to act in any of these cases by the governor or inaction would be subject to a judicial review. And it will also enforce democratic accountability and also to ensure legislative process is not obstructed because of this arbitrariness by the governors. But these are the time frames given for the governor of the state. There is one time limit given for the president of the country as well. See, previously we have discussed that the governor is having 4 choices. Either to give assent, second is to withhold the assent, third is to send the bill for reconsideration of the State Legislative Assembly, and fourth is to reserve the bill for the president. Now, if the governor chooses to reserve the bill for the president, in that case, according to Honorable Supreme Court of India, Honorable President of India needs to act on that particular bill within maximum of 3 months. So time limit has been given for the President of India as well. And action on that bill needs to be taken in the 3 months from the date of receipt. And if the deadline is missed, Centre is ought to provide necessary and appropriate reasons to the concerned state as well. That is very important. And this has also upholded the legislative autonomy of the state assemblies. Also, the court says that inaction of the president or inaction of the governor would be considered illegal and would be considered as stalling the legislative process of the states, which would be considered unconstitutional and which would be wrong for our polity and would be against the constitutional principles and hurt the federal spirit of our country. So there are 3 principles, 3 judicial principles or social principles which can be seen in this particular decision. One is the principle of accountability, that the governor and the president is now made accountable for the bill presented to them for making a law. One is accountability. Second is judicial oversight. So the court has reiterated that they would be coming in front of the constitutional bodies they fail to deliver their duties. So second is judicial oversight. And third is policy efficiency. Now the state governments, the elected state governments, can pursue their legislative agendas more persuasively and more with a greater clarity and predictability. Because in earlier situation, most of the legislative assembly which were ruled by opposition, they thought that definitely the law is going to be stalled by the governor. But now that cannot happen. Now, if it happens, it will happen in a stipulated period of time. And maximum a governor won't be able to stall a bill for more than 3 months. So maximum time limit in taking action is 3 months. Beyond 3 months, governor won't be able to keep the bill with themselves, which is again a very laudable move by the Honorable Supreme Court of India. And while delivering this judgment, one last thing which Honorable Supreme Court of India also highlighted is that when a governor reserves a bill for consideration of the President of India, that is due to perceived unconstitutionality of the particular bill. Now in that case, the judgment says that President ought to seek the opinion of Supreme Court in this particular matter. Now the seeking of opinion by President of India from Supreme Court in constitutional matters and constitutionality of a particular law comes under Article 143 of our Indian Constitution. And the court has acknowledged that this is an advisory provision. It is not binding, but definitely this, and the court has reiterated that this is an advisory provision. It's not binding, but still the central or the president should consult the Supreme Court of India if such a bill from the governor comes to the president in relation to constitutional irregularities. Because who's a better judge of constitution than the Supreme Court itself? Which is why this one more decision under the judgment has been made. Now overall, if we see the judgment, it definitely alters and shapes the federal ecosystem in our country. And definitely going forward, the governor's powers would be much more limited than what they were before. So till now, the governor had the choice to not take any action on the bill. But right now, the governor is given a time limit. So government would be time bound. There is accountability set for the governor and accountability set for the President of India. Definitely, they are unelected heads. One is unelected head of the country, one is unelected head for the state, which is why accountability needs to be there. And Supreme Court's judgment, this 2025 judgment, has been able to ensure some level of accountability for both the president and governor in passage of laws and passage of legislative assembly bills, state legislative assembly bills in our country as well. Now, the last thing is that the Supreme Court used Article 142 in order to clear all the 10 pending bills. This Article 142, it talks about complete justice. and the court invoked Article 142 to directly deem the 10 pending bills as assented to already. And the reason given by the court was that the bills were kept pending by the governor of the state for very long duration, showing scant respect by the governor for earlier judicial guidance, which is why Supreme Court took this initiative. And Article 142 of our Constitution empowers the court to go beyond technicalities and deliver complete justice, especially whenever there is no legal remedy available for a particular course of action, where no legal remedy otherwise exists. So do let me know, what do you feel about this particular judgment and how it will change the quasi-federal nature of our polity and how it is going to shape the federal structure of our Indian Constitution and our Indian polity. I'll be very happy to read your comments. All the very best and have a beautiful day. Thank you.